Judge, you have to accept this evidence.
7 years, no trial.
Are you tired of bad case law? Then try People v. Kent. People v. Kent is great for Twitter, Facebook, and tough spills.
Thanks, People v. Kent.
Warning, the type and quantum of evidence necessary to authenticate a webpage will always depend on context. Use as directed.
Social media is being used more and more in litigation, but one of the biggest debates is, is it real? And not a philosophical question, but kind of more to do with foundation and authenticity, because unlike other documents, social media is, well, it's a horse of a different color. I mean, as you can see here, I can set up a fake page for anybody. So brass tacks, how can I show that Facebook post that promises to violate a court order or maybe do something even incredibly stupider was from that person? And even if I do show it's from their account, so what? Maybe they're claiming somebody hacked it. Bottom line, what are the rules for authenticating social media? Well, two cases set the stage. You have People v. Kent and People v. Brand. In both, the appellate court acknowledges that, well, anyone can fake a social media page. It's kind of like saying water is wet. And even if the prosecutor subpoenas Facebook or Twitter directly, which they can, all that really proves is that the documents are what they are from whoever opened that account. I mean, maybe the ex-wife created the fake page, or maybe you left your phone out somewhere and somebody just kind of jumped on it and started posting crazy stuff. Who knows, right? Since authentication is part of that foundational process, how do we as practitioners climb that hill? Well, the court in Kent essentially said, hey, let's not make perfect the enemy of realistic. And by looking to other foreign case law, they crafted together kind of the 6-part system for authenticating that Facebook, MySpace, you can still use that, right? Or Twitter post. So without further ado, here comes April to explain what those 6 factors are.
In Illinois, social media can be authenticated in 6 ways. First, the purported sender admits authorship. 2, they are seen composing the communication. 3, business records show that communication originated from the purported sender's device, under circumstances in which it is reasonable to believe that they had access to said device. 4, the communication contains information that only the purported sender could be expected to know. 5, the purported sender responds to an exchange in such a way as to indicate circumstantially that they were in fact the author of the communication. Or 6, other circumstances peculiar to the particular case suffice to establish a prima facie showing of authenticity.
As you can see, you don't need a smoking gun, but you do need to establish some kind of minimal nexus beyond the allegation that it's their account. Now, for those concerned that an angry ex, all they have to do is kind of set up a fake account with Photoshop pics, the court in both Kent and Brand note a vital caveat. Just because it's been authenticated doesn't mean it's a done deal. Authentication merely means there's sort of sufficient reason to convince the judge, the defendant, or opposing party likely made it. And that can be overcome by attacking the weight the judge is to give it. For example, if you have proof your ex has hacked your account in the past, maybe you argue that's what happened here. Or perhaps you argue that multiple people had access to your account or whatever. But again, the attacks go to the weight because the issue of authorship is always decided ultimately by the jury, or if it's a bench trial, the judge. As I said in the opening, more and more people are using social media, but the internet, as many have found out, is kind of forever. And if the client isn't willing to stay offline, they got to at least be aware of how their posts and messages could be used against them in the foreseeable future. Which brings me briefly to next week's broadcast, GLs and GL case law. Most of that broadcast is going to be about the boring stuff as usual. What I've covered here, however, is going to dovetail a little bit into that video because there are a lot of growing dangers out there. When someone starts going to town on social media, screaming about the judge, the GAL, opposing counsel, clerk of court, the Martians on the moon, what should we do as GALs? Is walking up and touching that line the same as crossing it? And I'll be using some contemporary examples to emphasize what I mean. So if that's going to be your cup of tea, hit that subscribe button to get notified when the video drops, because unlike my other broadcasts, this one's going to be kind of a, soft release, if you will. Anyways, that's all I have. Thanks for watching.